Welcome, everybody. My name is Matthias Risse. I'm the director of the Carr Center for Human Rights Policy, and it is my distinctive honor to welcome such a wonderful, distinguished group on this faculty consultation on transitional justice, a wonderful occasion, also continuing a fair amount of thinking that a number of you in this room have done on Colombia, and also a number of activities relating to Colombia that have happened here on this very campus of the Harvard Kennedy School. It is my very special privilege to welcome our, we have lots of guests of honor here today, but one who stands out is Juan Manuel Santos, the former president of the Republic of Colombia and a Nobel laureate, Peace Laureate, as you all know, who has been present here at the Harvard Kennedy School throughout this year as an Angelopoulos Global Public Leaders Fellow, and has made himself quite indispensable as a wonderful provider of public goods, which is why he keeps getting more invitations, since he has been so generous in offering his insights, including actually visits to our ethics class that, thanks to Diana's presence here, has included a couple of sessions also on the Colombian peace process, and our students were tremendously privileged that day to get a lot of insight from President Santos himself. So thank you again for that also. In addition, thanks especially also to those of you who came from further away and are joining us here today. This is really the level of expertise in this room, local expertise about Colombia, expertise about lots of aspects relating to the Colombian peace process, to conceptual issues about transitional justice generally. The level of expertise and all of that is really quite extraordinary, so we really must hope that nothing happens to this building today, otherwise this would be a major setback to the causes of transitional justice in the world. Since I'm being recorded here, and we may use this recording for some also future purposes of giving a sense of what this meeting is about, let me just say a couple of things that you all know, but some people who may be watching that in the future do not know, namely that the background to this meeting here is the peace negotiations between the government of Colombia and the FARC that were finalized in a document dated 24th of November 2016. That is the grounding document for this meeting here today. And that agreement also included set up an integrated, what was called then an integrated system of truth, justice, reparations, and non-repetition, which is basically generating the agenda for this day here today, which is a set of judicial and non-judicial mechanisms that are really quite far-ranging. So the sheer complexity of these documents and the whole process, of course, is quite staggering and really quite mind-bending. So the topics covered there range from amnesty and pardon for FARC members. A truth commission was set up. A special jurisdiction for peace was created, and there was a number of measures also to provide comprehensive reparations to the victims of this very long conflict. So the conversation today will be very much about hearing perspectives on how this process is going, these different components of that integrated system, how they are being implemented. The recent news from Colombia about the seriousness of the current Colombian government has been somewhat discouraging, and I suppose one topic today will be, I know that when President Santos was asked about this earlier, how discouraged one should be about the news, he was always very optimistic that he felt very confident that the mechanisms were sufficiently robust that all these little troubles now were anticipated and can be dealt with. So I'll be very curious to hear how that is still the perspective on these matters. The Carr Center for Human Rights Policy is tremendously honored to be the host for this event, and in that spirit I'd like to very much thank the organizing committee, Catherine Sicking and Sushma Raman and Gabriel Cifuentes and Diana Costa-Navas. I know this has been a very meeting-intensive process that led to this particular meeting. So I was saying to the organizers before, you must be both, you must be also feel, both excited but also relieved, that the meeting of all meetings has finally come. So many thanks from my end. Before turning this over to President Santos, I can't help but just add a couple of thoughts of my own as a philosopher to what we're doing today. So there's on the subject of transitional justice, there is one very famous quotation from the Roman historian Tacitus that is often brought up about the ways the Romans made peace. So Tacitus, he's attributing that to a Caledonian chieftain, so it's really a Scottish chieftain who is saying that, but it's really Tacitus criticizing the Roman Empire and the way it makes empire and peace, and he says, so basically, to ravage and slaughter and usurp under false title, that is what the Romans call empire. And then the formulation continues, ubi solitudinem faciunt pacem appellant, so ubi solitudinem, in this case it's not a reference to Colombian literature, right? Solitude, he means, is the land of desolation. Yeah? When they are creating a desert, then they call that peace. You know? So when they don't leave a stone standing, then they're calling that peace. So Tacitus doesn't have a very high opinion of the way the Romans made peace, but of course that's a fairly well-known and often referred to citation in the peace literature. But of course it also draws a question to the agenda that we have here today. So what if you can't vanquish your enemies in this way that creates a desert, or maybe but if you have moral qualms or qualms of other sorts that you don't want to go this way, then how are you making peace if you are not doing peace the way Tacitus thought the Romans made peace? And that of course is a substantial question, both empirically and also conceptually. So for philosophers, this whole term transitional justice actually is quite fascinating. It captures a deep conceptual innovation. So if you go back in the justice discourse as philosophers have had it, we have always understood, or we have long understood, distributive justice and rectificatory justice. You know? So these are both capturing certain ideas about appropriate assignments, where distributive justice is about how we are sharing out things that we do together. Rectificatory justice is about how we are making good on things that went wrong. So it's in that some abstract level always about appropriate assignments, but this idea of appropriate assignments presupposes a functioning society, right? Not a broken society, not a situation where everything breaks down. Situations where things have broken down have traditionally not been addressed under the heading of justice, and in that sense it is a deep conceptual innovation that we are talking about transitional justice, and it captures really two things. One is a philosophical aspiration that these ideas about appropriate assignments that we understand from societies that are functioning reasonably well, that they have a place in scenarios of deep conflict, right? That we, as a matter of human concern, want to think about scenarios of conflict along such lines also and have a place for justice there. And that's a deep philosophical conceptual innovation. And then, of course, there's also a deep empirical hope and expectation really expressed thereby that a truly lasting peace in fact is one that hasn't created a desert in the process, but a truly lasting peace is one that can be described under the heading of justice. So in that sense, transitional justice, both a deep conceptual innovation and expressing an enormous hope for the future of humanity. So in that spirit, Colombia is very much, of course, of enormous interest in its own right. People have good reason to care about Colombia, obviously, but there's also in a way a case study before the background of general human concern and human history unfolding here. What can we learn also for other purposes of transitional justice? So without further ado, again, we are delighted to have you. I'm thrilled to see all of you here, and so please now join me in welcoming back President Santos.
Well, thank you very much, and I'm delighted to be here, delighted to be in this meeting. I want to thank Matthias for his encouragement, his participation, and Catherine also. Thank you very much for making this possible. Shuzma Rahman, also the executive director of the Carr Center, of course Gabriel and Diana, who have been working very hard, and all of you, thank you for being here. I thought that a good way to start was to give you an update of where I think the process is going, the difficulties that we have encountered, how we have been handling those difficulties. And then I thought that the best way to take advantage of such a special group of privileged minds that are around this table with respect to our peace process would be to try to establish what would be a reasonable measurement of success or failure in each one of the rights that are going to be discussed: truth, reparations, justice, and non-repetition. That would be extremely helpful, because as you very well know, we are doing something that in a song in Spanish is called "Se hace camino al andar." We're trying to make things happen as we go on, and the more we have a academic, conceptual vision and explanation for the things we have done. Many times we do things and we don't know why we do them. Then we have to find a reason that we can use to say we did this because of this, and also try to discover the best way to go about for the future. So this type of analysis of different people with different perspectives discussing these issues are of great help. And I've always been convinced of the importance of collective intelligence and intelligence that has some distance with what is happening. That's why the first thing I did in the peace process was bring some foreign advisors, which was quite awkward at that time. Everybody was a bit shocked, to advise me on how to go about the peace process. And they ended up being extremely, extremely useful, because they came with a perspective which was not, in a way, tainted by the local current affairs that was happening in Colombia. So that's why I think this group would be of extreme value for Colombia and for the future of the peace process. And as Matias was saying, I have always been on the optimistic side of how this process not only has advanced, but also how shielded it is to whoever wants to bring it down or stop it. And why do I say this? Because I think we did a good job in setting the basis for this process to have a guaranteed continuation from the legal point of view and from the, I would call it, ethical, political point of view. The legal point of view, we all know that the Constitutional Court is very much in favor of the peace process. They won't change. None of their members will be changed in the next 4 years. And they made a ruling. Not only did they accept the peace process as it was negotiated, but they said no government can change or can approve a law, no Congress can approve a law, no government can make a decision that goes against the implementation of the agreement for 3 presidential periods. This is quite unique. Was criticized by many, but it's a fact. It's a ruling, and they have started applying that already. You probably have heard about the intentions of this government to change aspects of the agreement, and the first way to try to change the agreement was by objecting to a statutory law that gave the special justice their procedures. The president, against the advice of many people, insisted in presenting 6 objections on 6 different points. Those objections were defeated in Congress, in the House of Representatives, just a few days ago by an overwhelming majority. This was a very special vote because, in a way, it said, listen, politically, don't continue to try to change the peace agreement because you will find a big opposition. The president was also told, this is a stupid step to take because not only will this be declared by some as a declaration of war in the Senate, but outside. This will encourage many of the protesters to go to the streets, and it will encourage the international community, which is very much in favor of the correct implementation of the peace process, to criticize the government. And that is exactly what has happened. The international community has warned the president and the current government. We are in favor, and we wish for you to simply implement the agreements. This is an agreement that was not made by a government. It's an agreement made by the state, which is one of the reasons that the current government was trying to use for some of the actions that it has taken, that the government was, the last government was the one that signed, and that it didn't compromise this current government, which is rather bizarre way of interpreting how government works. Anyway, what he has encountered is a tremendous opposition on all these fronts. But besides that, the Constitutional Court made a ruling that no matter what happens, they will again intervene with the intention of guaranteeing the implementation of the agreement. So if any decision is taken in this, or what's going to be taken, because now what I think is that these objections will be refused in Congress, already in the House. I think that in the Senate something similar will happen, and the president has no alternative than to sign this law. And he had already announced some constitutional reforms to change the agreement, but this is a very important warning of what is going to happen with those constitutional reforms. They will not be approved. And just follow Voltaire's advice, think the worst. If they're approved, the Constitutional Court will strike them down. So that's why I say that legally we are very much shielded, and what is happening is a proof of that. So the special system, we call the special judicial system, is working. They have been, in a way, satanized by the people who are against this type of justice or against the agreement. But I have told them, and I think this is the correct way of dealing with these type of things. You simply follow, stay the course. Don't worry about the criticism. You do what is needed, and do it fast. This is something which is important to start producing results as fast as possible. Some people say, well, the government is going to cut the funds to the special justice system. That will not happen. The funds, they might not be very generous, but the justice system has a guaranteed a minimum amount of resources to function correctly. So what is happening today is that the government's intention to change the agreement and to weaken the special justice system has met a very effective and fierce opposition that will not allow the government to be successful in its intentions. I hope that this is sufficient warning for the government not to keep insisting. However, there are many people who use this as a political strategy. No matter what happens, they have to criticize the special justice system as they have been criticizing the peace agreement since the very beginning. And this is one issue that I would hope that you could help us go through and give us some advice of how to do it. You all know how difficult it is to explain to a normal citizen what transitional justice is, especially when you have had so many victims and you have had so many war crimes and crimes against humanity, and you are allowing these people who committed these these atrocities to go free or not to pay X amount of years in jail. To use that politically is very easy, because you go after the emotions of the people and say, yeah, for example, at this very moment, there's an issue on the children that have been sexually abused or that have been drafted. The children in any society has special sensitivity, and so they're using that as one of the major of the changes that they want to do has to do with this type of crime. So they will always find a reason to try to touch the emotions and criticize what has been done. But that's a fact of life. That's something we have to live with. Nobody in a peace agreement, not everybody can be happy. And as I've said it many times, when you draw the line between peace and justice, there will always be some people wanting more justice and other people wanting more peace. It's impossible to satisfy everybody. So the constitutional, the special justice system should simply continue. They were afraid that something would happen with these objections. I hope that they are now more at ease and that they will continue doing their work. So what they need, and I think the country needs right now, is to start seeing how can we measure what is happening. Of course, it takes time, but this has been a very ambitious agreement. It's the first time that the transitional justice is applied under the Rome Statute, and it's not easy to understand by the majority of the people. To make it more understandable and more measurable is something that I think is extremely important at this time. So this is one of the challenges that we have. How to, I would say, lower the expectations in in many of these issues, because that's another way of criticizing. Oh, so you're only going to punish X% of the people who committed these crimes. Well, this is no justice. This is impunity. That's very easy to say, but the contrary is, if you want to judge everybody, the system will collapse. So how do you explain the concept of the maximum responsible, the people who were really responsible? Those are the ones who will be judged. It's not easy, but it's necessary. Or the truth. There's a big gap between the expectations and what can be done. You all know how we have been trying to be very, I would say, too ambitious in our policies to repair the victims, since we approved the law that, by the way, Senator Cristo, or former Senator Cristo at that time, pushed with enthusiasm of repairing the victims since the year 2012 and restituting the land to the peasants. We have already repaired a very high number, which compared to any other agreement is way above any other situation, but compared to what we put ourselves in, it's still very small, because there was a ruling by the Constitutional Court declaring victims everybody that was in some way displaced. So that increased the number of victims from 800 or 900,000 to more than 8 million. And they have expectations on being repaired and also on the truth. There we have another challenge of how can we, in 3 years, and I think that we're going to have to extend the limit of 3 years for the Truth Commission, but how can we find the correct equilibrium in between what is possible and what is sufficient? Because every victim wants to know the truth, their own truth. Where is my daughter? Why did they bomb my town? What happened to my father? But you can't find the truth for every victim. You can't find the truth even for a high percentage of the victims. You won't have time for that. So what I think, and this is something that I would very much like to hear from you, is that you have to be selective. Maybe get some very symbolic cases and find out the truth of what happened there, that in a way will reflect what the 50 years of conflict was. How to do that, how to select it, how to lower the expectations is something that I think we are urgently need to have some ideas on that. And I think the Truth Commission also. Because they've been pressed. The victims of the FARC, the victims of the paramilitaries, the victims of the army, and all of them want a piece of the cake, and all of them want a large piece of the cake, and the reality is that all the cake is very small. So how to balance that is a tremendous challenge. And some practical things about the justice system. What type of punishment, of sanctions? We said, with the effective restriction of your movement, to what extent that is, what does that mean? I think that we need some more concrete ideas on that. the special court doesn't yet know exactly what type of restrictions they're going to impose on the people who are condemned, and what type of reparations, and how will they individually start repairing the victims with what is something that would be acceptable and at the same time possible. So, I mean, there are many issues that, as you can see, are on the table, and I think that the way that you have ordered this discussion of each of the rights, I think is a great practical way to do it, and all the ideas that you can put on the table, and hopefully we can get some advice and conclusions would be of extreme importance for the process in Colombia. We are eager to have these type of ideas, to have this type of input, and not me personally, but people who are now working for the implementation of the peace process. I will finish. I will end here, and we might discuss, or I would answer any questions in the course of the afternoon. But again, I want to thank you, because I think this is extremely important. All the advice that you can give us, especially with the experience that you all have had with Luis Moreno, we've been discussing this for many years, of how to go about it. For example, one specific problem that our Attorney General said that he had brought from the International Penal Court, and he went and made a big fuss in Congress. Fortunately, the congressman didn't pay attention. Was that your predecessor, your successor, that she had warned that she would intervene immediately if they don't approve the objections, and she would that she would intervene if the objections that the president had presented were not approved, because the Attorney General is playing with the government. But we had other channels of communication, and we said that was not true. But this is the type of opposition we're confronting. People who simply distort the truth with without getting a red face. Anyway, all this is part of the discussion. So again, thank you so much, and I think this is extremely useful.
So I'm going to both give a brief introduction, and then I'm just going to talk kind of about how how we're going to move ahead with today's workshop. And first, just repeating everyone, thanks to all of you for being here. We're very honored to have President Santos here with us, and also Juan Fernando Cristo, who was not on the original agenda, but as the author of the victims of the plan for the victims unit and for reparations. We're very honored to have you here with us. I also just, while I'm saying thank you, really it was Gabriel and Diana who were the people who really made this happen, and then with the help of Sushma. I want to call out too, because you may not know her, Patricia Garcia Rios, who's sitting here in the corner. She is the filmmaker and the author of the amazing multimedia case that we sent to you. And so that's a case that we've been using here in our teaching. They used it in the ethics courses. We've used it in negotiation courses. I'm using it in my global governance course. I've used it in my politics international law class. It's an amazing case, and it's available from the SLATE program here at the Harvard Kennedy School. First I want to remind us of the questions we put before us. Each of you got a list of questions. They're the same questions for everybody, but kind of tailored to your issue, right? And they're basically saying, think about, assess the ambition of the policies, suggest acceptable thresholds for the implementation of these measures. And this is what President Santos called reasonable measures of success or failure in each case. And then finally, formulate recommendations for the leaders who are currently implementing these mechanisms. And so this approach is really consistent with my own approach to actually human rights and transitional justice. And that is, I've very much focused on what I call empirical comparisons. My most recent book, Evidence for Hope, stressed the importance of using empirical comparisons to be able to measure how far we've come. And so I'm very sympathetic to this notion of reasonable measures of success and failure based on our best empirical evidence. Okay, now, President Santos used the term how to lower expectations. I actually try to deal with the same issue, but I use a different way of talking about it. The way I talk about it is I say, a lot of people, including the human rights movement, do comparison to the ideal. And that's the way the human rights movement has long made its arguments, and we understand that's how they do it. But we, as scholars of transitional justice, are mainly using other kinds of measures, and that has to do with, in this case, comparing the Colombian case to all the other cases that we know about. And so with a group of colleagues, I built something called the Transitional Justice Database. It's at transitionaljusticedata.com. You can browse all of our data. We have data about prosecutions, truth commissions, vetting, reparations, customary forms of justice, international prosecutions, domestic prosecutions, foreign prosecutions, civil prosecutions. The point being, when we talk about a case like Colombia, I always situate it within the context of all the other actually existing cases in the world, and not only to my fondest wishes for transitional justice in the world. So I would say it's not so much lowering expectations as it's saying, let's just compare the Colombia case to all the other existing cases in the world. And I think if we do that, we see the kind of amazing ambition of this program relative to everything that's done so far. Now, we also have the opportunity with here at Harvard and at the Carr Center to do a evaluation of the victims unit. Here, Doug Johnson, Fang Fang, who's here, and Patrick Vink, who's not here but might be at the very end, were able to work for over a year doing an evaluation. And it was there that we kind of took our breath away when we realized how ambitious the reparations program was. So we know that recent events in Colombia are putting our transitional justice under attack. I was actually quite relieved to hear you say that it's legally shielded. Okay. Now, let me just turn to the events of the day. The first thing I want to say is, as soon as I finish talking, we're turning off the video machine here, and that's because we want to have an informal discussion and informal consultation. Okay, but we will keep audio taping. Okay, and the reason we're doing that is we don't want to have so many smart people gather in the room and not be able to produce a report. Okay, so we will audio tape, and we're going to use it to produce our report. We're not going to, broadcast or podcast it or anything, just produce a report. And so we're going to assume that people are on the record unless you take yourself off the record. Okay, but you're welcome to take yourself off the record. Okay, and then we're going to use it to produce our report. The report will be shared with all of you, and it will be posted on the Carr Center website. Now, originally we thought, what? Oh, right, you do have audio release form here, video audio release form we'd like you to sign. Okay, we're not going to do introductions for everyone. You have bios. You've all received the bios, everyone, so no long introductions. We want to move directly to our purpose. Your instructions said we're going to ask each of you to speak between 5 and 10 minutes, with 10 as a strict upper limit, and that's because we want time for discussion. So everyone's going to get a chance to have plenty to say today, but we want to have more time in our discussion and less time in our formal presentation. So the moderators have been instructed. They have the sheets in front of them to hold people to that time. Okay, so I don't want anyone to take offense. The reason we're doing that, we're doing it for everybody who's doing it, is we have time for discussion. Now, the other thing, apparently, originally thought we wouldn't let anyone tweet, but President Santos himself said he's okay with tweeting. But what it means is if someone has taken themselves off the record, obviously we're all going to respect that, okay? Finally, however, we're not videotaping anymore, but we're going to ask everyone in the room to be willing at the end. We're going to end at 4:15, you know, and we have until 5. We're asking everyone in the room to be willing to do a 1 to 2 minute videotape of your, if you could have just 1 to 2 minutes to say something to a general audience, mainly along the line of recommendations, the final question you got, what recommendations would you give, okay? We'd like you to not leave before you tape that videotape. Here's Sarah Peck, she's our communication director of the Carr Center, she's going to be working on it. So this is a way of being able to make sure we capture something from each person who's here in terms of your expertise without having to film this whole time and then cut and edit the filming, okay? So please, I want to let everyone know now so you'd be thinking about it a little bit. It's hard to do a 1 to 2 minute presentation, but I think if people are thinking ahead, they can be able to do that. Okay, so, and then these video clips will be uploaded pretty quickly to the Carr Center website. The report will take longer. So I'm going to just stop there. I'm going to turn it over to Doug Johnson, who's the first moderator of the first panel.